Hey, I'm Henry Quillian here at Taylor English Duma, and we are continuing the Quillian's Kernels series. Today we are going to talk about answering and responding to the complaint. In the past we've covered filing of a complaint, service of the complaint, and discovery with or without the complaint, and now we're going to cover responding to the complaint. Something I've not done in previous sessions is remind those viewers that this is not a legal opinion. You should seek your own counsel if you have a lawsuit. This is an effort to expand the knowledge of the people involved in the seminar, and also to help people out in the community understand better the legal processes we have. So we have a situation where somebody has walked in your door, hopefully given you a nice retainer, and they have something called a summons in their hand and something called a complaint attached to it, and that document alleges something against them, seeking recovery in a lawsuit. And as we have said in the past, we're talking about lawsuits involving the state and superior courts of Georgia. And let's assume for the moment that this lawsuit is a little bit more complicated than the very straightforward lawsuits we've talked about in the past. Let's say that it has a breach of contract claim where they have alleged that your client entered into a contract, didn't fulfill the contract, that all conditions precedent have been fulfilled, and that they want to recover damages from your client. And let's say that it has an extra claim in it that says something like, and by the way, your client's mother is a whore, and further that it says that your client made misrepresentations in the mail concerning performance under the contract, and that damaged the plaintiff. So we have a variety of allegations in this complaint, and what we want to talk about in this session is what are sort of the rules for answering a complaint, what has to be in the answer, what has to be considered before an answer is filed, when does the answer have to be filed. Does anybody have a idea of what sort of deadline you'd have to set for yourself if somebody came in with a complaint, a summons, and a certificate of service or return of service from a sheriff saying that a complaint had been filed on January 1st, 2012? What sort of deadline should you set for yourself if it's January 5th?
Well, you said filed. When was it served?
I'm sorry, the return of service said that the complaint and summons had been served on January 1st, 2012. Good question, though. Big difference. What sort of deadline?
Answer date. I'm sorry, go ahead. Yeah, answer date.
And the answer date is?
Is it federal or state court?
That's state or superior court.
Okay.
In Georgia.
30 days.
Okay, which means it is what day?
January 31st.
It's 30 days from January 1st.
You don't count January 1.
So you start on
2nd, so it's 31st.
31st, if that's a day when the court is open.
Right.
Correct. What if it's a holiday or a weekend?
Because it's the next business day.
Okay. So you've got this amount of time to work with. What other considerations must you take into account when you're evaluating this complaint? Preliminarily, we've got potential for, let's see, we got to figure out what the defenses would be, right? You got to determine whether you still want to stay in state or superior court. What's that called if you want to try to move it up to federal court?
Removal.
And generally, just what is removal in a most general sense?
Removal in the most general sense is, in order to get to federal court, you need to have some reason to be in federal court. One of those reasons is federal question or diversity along with amount of controversy. So let's get it from the state or superior court into a federal district court.
Okay, so we're not going to go into this in any depth whatsoever other than to make sure it's something that's considered. But there are certain cases that can be moved out of a state court into the federal court system. And that's the process for doing that is called removal. And there's very limited types of cases that can go into federal court. You have to have some sort of jurisdiction in federal court, and you have to make a determination whether you can move that case or not. And if you were to try to do that, what would be your deadline for doing it?
30 days from service.
30 days from service? To do what?
To file
The papers necessary to remove it? Okay. So you have, in Georgia, you have a similar, or the same, time period for making that determination if you're dealing with the absolute last minute determination.
Now, the new rules that just came down, though, can sort of alter that.
Okay, what are the new
In the 11th Circuit,
rules?
it's always been that way. In the 11th Circuit, it's always been where there's multiple defendants, it's the last served defendant from where that 30 days, that last served defendant can still file their removal and you can join into it up until their 30 days, which may extend it. But in the 5th Circuit, it didn't used to be that way. You used to have to go, whoever got filed first, it was 30 days from when they received service, the first defendant received service, and if you didn't comply, then the removal rights were gone. But it's been codified, the 11th Circuit rule has been codified, and now that's across all the circuits.
Okay, so that's an initial consideration we need to make. Just remember, put that on your checklist, removal. Now, obviously, you're going to have to develop the facts that you would need in order to properly respond to the complaint. Let's assume that this is a concisely pled complaint that has individual facts alleged in separately numbered paragraphs. What sort of guidelines do you go by when you determine how you answer a complaint? Can you just put down anything you want in response, whatever sounds really good for your client's position? I hear one no, I don't hear any other no's. So I assume that most of you say you can just put whatever sounds good for your client's position. Is that right? What do the rules say about that? Because when in doubt, you
Check the rules.
read the rules. Right. Well, we've got the rules of pleadings. Pleadings are defined in 911(7). And so you have to know what the pleadings are. Basically, what are recognized pleadings in Georgia? Are they everything you might stick in a file called the pleadings file at your office?
No.
Nope.
No. They are the complaint, the answer, a third-party complaint, and then the answer, third-party answer, and if there's a cross-claim, a reply to the cross-claim if it has been allowed, I believe. But if they're all set forth in 911(7)(a), those are the only things that are actually called pleadings. Now, if 911(8) talks about what the means are for responding to a pleading, and in 911(8)(a), they talk about how a claim is supposed to be set out. 911(8)(b) talks about the rules for responding. So, like I said, can you just say whatever is good that sounds good for your client? No. You have to, a party shall state in short and plain terms his defenses to each claim asserted and shall admit or deny the averments upon which the adverse party relies. If he is without knowledge or information sufficient to form a belief as to the truth of the averment, he shall so state, and this has the effect of a denial. Now, one way of it goes on to say that the denials and admissions shall fairly meet the pleading that has been asserted. So let's assume your client is a male, and the complaint says defendant is a male. Can you deny that, or should you deny it? No. One of the purposes of the pleadings is to narrow the issues that are in dispute in the case. And so knee-jerk reaction of denying everything not only would make you look incredibly silly, but also violates the rules of pleadings. Now, sometimes, just to test, because I find that sometimes a lot of defendants will just deny everything, sometimes I put in a two-word paragraph in the complaint, time passed. Every so often people deny that because they don't want to admit anything. Now, what about this rule, this portion that says, if he is without knowledge or information sufficient to form a belief as to the truth of an averment, he shall so say, and that has the effect of a denial. Do you actually have to put that language out in your answer if you really have no idea what the truth is of the averment that's been made in the complaint?
Probably should, as a practical point, so it's not admitted against you.
In other words,
You're saying, can't you just deny it? Do you have to put without knowledge or information? Or can you just say deny it?
yeah. Can you just say deny it,
Even though you don't know one way or another?
even though you don't know one way or the other?
I would say you cannot, because that's a false denial.
That would be a false denial, and it might violate 9/11/11, which says that if you sign the pleading as an attorney, that means that you have read the pleading and it's not interposed for delay. And if you deny a lot of things that might actually be true, that arguably could be delay. Furthermore, it does not narrow the issues in the case, because if you deny something, the other side is going to assume they have to prove it. Whereas if they know it to be true and you have not denied it, you just put down you didn't have sufficient information or knowledge to form a belief, then maybe they'll rely on what they think they can prove without worried about it being contested by you. So this is specific language that's mentioned in the rule, and a lot of people do not use it in their answers. They just say something like, that's not against my client, or I don't have enough information to answer this, instead of actually laying out the law, which is without knowledge or information sufficient to form a belief. And there's a case that I provided to y'all from the Northern District of Illinois, which is 199 Federal Rules Decisions 276 2001, which bemoans people not looking at each of the words of that rule, and they say, the judge says you ought to look at each rule, and if you don't have enough to form a belief, that's one thing, or if you don't have enough information, that's another thing, but you ought to look at it as a whole and figure out whether you actually have enough information or knowledge to form a belief. If not, you can deny it, and it's deemed to be denied. Now, what if you found that out after the fact, you find out that what you previously didn't have enough information concerning, you remembered, is actually true? You found something in your file that shows that averment was actually true. Do you have a duty to amend your answer?
There's no duty to amend the answer.
Okay.
And even more so, it's very important, I think, to point out, there is no obligation to run out and investigate to try to develop sufficient information to respond to the pleading, unlike in other contexts where you have an affirmative duty to make a good faith effort to investigate. So ignorance is bliss in responding to a complaint.
Okay, so, and whose knowledge do you look to in answering a complaint? The client's knowledge. So if you as the attorney just happen to know something the client doesn't know, do you have to spew forth everything that you know into the answer, even though the client doesn't know themselves? No. Okay. So within this answer, you're supposed to go step by step and Some people cover it one way. Some people will say, I admit these things, but deny these things if there are multiple facts alleged in a complaint, in a paragraph in a complaint. Some people say, I deny everything except I admit these things. So if you had multiple facts alleged in a complaint, in a paragraph in a complaint, can you just, and some of them are true and some of them are false, can you just deny them all? No, you need to admit those things that are correct, upon which the other side is obviously relying, and deny those that you believe are false, and then you can also separately state, with respect to the facts, that you don't have sufficient information or knowledge or information to form a belief as to the truth of them, that you deny those on that basis.
What about the use of the phrase "deny as written"? Or I've seen that before, where they, it's sort of like it's a play. Like it's not, the way you wrote it is not accurate, so I'm going to deny it, even though the substance of it may really be true. I'm trying to think of an example. The sky is blue. Really, the sky is more like light blue, not blue. So I'm denying it as written.
I've seen that too in tax court.
Well, let's put it this way. It's omnipresent, but I don't think in compliance with the rules. And I think it could put you into jeopardy if it turns out that an objective person looks at the allegation, looks at your denial, and concludes there's no way you should have denied that.
Are there clear requirements that require a plaintiff to actually succinctly in each averment to keep it to a single thought, not multiple or combinations of allegations in a single averment?
The answer is yes, but there is latitude. Would y'all agree with that? That even though you're supposed to allege within a single paragraph a pretty particular set of facts or fact, that there is some latitude. You're not supposed to have long, rambling paragraphs with all sorts of things in them. But sometimes in order to communicate what you're stating, you have to have some diction or some descriptive terms within the paragraph. And let's see, that is actually within the rules, which is, I think, 911. B, I believe. All averments of a claim or defense shall be made in numbered paragraphs, the contents of each of which shall be limited as far as practicable to a statement of a single set of circumstances, and a paragraph may be referred to by number in all proceedings. Each claim founded upon a separate transaction or occurrence, and each defense other than denial shall be stated in a separate count or defense whenever separation facilitates the clear presentation of the matter set forth. So it more or less focuses on the set of facts relating to a circumstance rather than having a bunch of 3-word paragraphs, each with a separate fact.
Hey, Henry, can I make a point or just tell you about my experiences? But I'm not in the habit of using that denied as pled. I probably have used it once or twice. And I think people who use it are probably they're being conscientious, and they feel that they can't fully deny. But an answer, as I understand it, an answer is not the place to testify. It's not the place to give your version of the story. And sometimes you can't really deny it without giving an explanation. But the answer isn't the place to give an explanation. So I think that's what people would say denied as pled, because you take issue with the way choice of words, that kind of thing. That's the way I've always looked at it anyway. And also your last point, I've seen complaints or counterclaim paragraphs that go on for a whole page, and sometimes you just, and it's interesting that's in the past, I never focused on that before, but I'm sure you've done this before too. But when you're responding, you would respond to a counterclaim. Say you're responding to a complaint, sometimes you gotta just dig in there and just go sentence by sentence. You know, in response to the first sentence of paragraph 15, defendant says this. In response to the second sentence, admitted, you know, you sort of take it piece by piece.
Yes, with respect to responding to a complaint, it's always important to step back and take a big picture view. Not only do you have the technical requirements and the need to be responsive to the complaint, but for instance, if you have this long paragraph, just because it's long and says a lot in it, you might not want to, as a defendant, deny the whole thing because just out of laziness, for instance, because it would violate the rules, but also it could frustrate your positions in the case or otherwise cause other problems. So if the complaint is so rambling and long, you could make a motion. Does anybody know what motion you can make?
Motion for a more definite statement?
You can make a motion for a more definite statement. But otherwise, you're going to probably need to generally answer to the best extent you can first while you're doing that, because you're never going to get a ruling on that motion for a more definite statement in time. And then maybe they'll break it down into a clear allegation if the court doesn't order them to do so. But, yes, ma'am.
I think when you talk about the big picture, to me, when I'm doing an answer, the only things that I really care about are making sure I don't admit something that hurts me and that I don't miss what is truly an affirmative defense. Everything else is icing on the cake, quite frankly, from my perspective. And when I'm faced with a complaint that has these enormously long paragraphs, sometimes I have started my response to paragraph X by asserting that it is not in compliance with the rule that requires a concise allegation. Therefore, in good faith, we are going to respond to it, but we object to any burden to parse each sentence. Probably unnecessary, but I think that's a little bit more belt and suspenders. And the notion of deny as pled, if the example I see all the time is where a statement is taken out of an agreement or from an oral conversation and so-and-so said X. Unquestionably, that is a true statement, but it is taken totally out of context. And if you had read the very next sentence in the document, it would explain that sentence. So I think that's what people try and do when it's clearly true as stated, but it is misleading in context. And while an answer to me is not to plead your case, I would feel more comfortable, and most of my clients feel more comfortable, to say admitted, but show, and then go on to make an affirmative statement to put that statement in context.
Right.
Well,
And there's nothing that I know of that precludes you from providing that kind of further explanation in your answer beyond just an admission or a denial.
What about when you say, I see people do, this is not a fact, this is a legal conclusion and therefore does not require an answer to,
To the extent it doesn't appear by document.
Right. Or where they'll say, this document is the best document of evidence of its contents and, but to the extent that a response is required, da-da-da-da-da-da. I mean, it doesn't seem like the rules provide for any of that variation. Those are all things that people do.
And the one about saying the document speaks for itself, that is a incredibly dangerous statement to make.
Right.
If you are going to contend that there is any ambiguity whatsoever with respect to that statement, because you just admitted that on its face,
Right.
it means exactly what it says.
There are also some court, there are also some court cases that critique the use of the document speaking for itself, and I don't remember which circuit. It may be 11th, it may not. I can find a case.
This one
was
did.
it?
Well, Mr. Ross and Mr. Rosenkopf have just talked about the situation where some defendants say the document speaks for itself. And a court, the same court in Illinois, says this court has been attempting to listen to such written materials for years in the forlorn hope that one will indeed give voice. But until such writing does break its silence, the court will continue to require pleaders to employ one of the three alternatives that are permitted under Rule 8B.
To Mickey's point, I was in the habit for a long time, especially with contracts and construction cases, you're always dealing with contracts and written documents. And part of how I was kind of trained early on was to say the document speaks for itself. And I stopped doing that for the exact reason that Mickey brought up, because I had a case where the defendant said the document speaks for itself. I moved for summary judgment. They tried to bring in parole evidence, and I used that against them, because you can't use parole evidence to alter the terms of an unambiguous contract. And I used that answer as part of my reply in saying that it's parole evidence, and they've admitted that it's an unambiguous contract by saying that the document speaks for itself. So I've actually done that, and I don't put that in answers anymore.
So I guess what you're saying, Mark Carter, is you can learn by other people's mistakes.
Yes.
By you sticking it to them. And if it's a mistake that you might have been charged with in the past, at least you got away with it.
I was going to say it's only by the grace of God that someone in this room isn't saying they used it against me.
That's right. So the other thing that Mickey brought up was the need to make sure that you, one thing he said was, I don't want to make an admission that hurts me. I assume we can clarify that by saying an admission that is incorrect that hurts you.
Yes.
Do you have a duty to admit facts that you wish you didn't have to admit?
Absolutely. Yeah.
Okay, so the answer is yes. Otherwise, you're not fulfilling your duties as a lawyer. Your duties are candor to the court, and you're potentially violating 9/11/11, which is delaying the action or by denying something that should be admitted. And so our job is to take the facts that we know to be true and to deal with them, try to come up with defenses, legal defenses, etc. Now, one of the things he also mentioned was affirmative defenses. Can you file an answer without any affirmative defenses if you actually have them?
You can.
You can. Sure.
Okay.
I would not.
Are there any affirmative defenses that if the facts support them on behalf of your client, you have to raise them in the answer?
Basically all of them.
Well, there are only certain ones that are set forth, and I'm not sure they constitute all affirmative defenses.
Well, if it ain't listed as an affirmative defense, then it doesn't have to be asserted. And everybody does it. I'm as guilty as the next person, as clients like to see it. And you've got this laundry list of defenses that by no stretch of the imagination are affirmative, in the sense that it's not defendant's burden, it's an element of the plaintiff's case.
Right.
But people do it and will do it until hell freezes over. You know, they have 3,000 defenses, and what I get, what really gripes me, is when people put the word affirmative in front of every one of those defenses. I never have filed an answer in my life that uses the word affirmative in front of the defense. There's absolutely no need to do that.
Is that because it charges you then with some burden that you would not otherwise have?
Because either you're going to put affirmative in front of the true affirmative defenses, and the other ones
Are going to be just
it's
defenses?
just defensive, whatever the heck that means. Or why take on a burden that you may not have?
That's right. Now, what if you lay out all that stuff as a defendant, all those defenses that just sound really good to your client, makes you look like you're really on top of things? If you're up against an aggressive plaintiff, what are they going to do?
Strike it.
They could move to strike it. They could ask you interrogatories to state every fact that supports your defense that,
Right.
as set forth in paragraph or affirmative defense number so and so. They can stick it to you. It can make your litigation a whole lot more expensive, or you have to somehow negotiate the withdrawal of the affirmative defense, because if there's no support for that, I'll call it affirmative defense. If there's no support for that defense, what have you done? You potentially violated 915.14, OCGA 915.14, by asserting a defense that has no merit whatsoever. And sometimes people just list them one after another as if they actually existed when they don't. So, but getting to the important part that I was trying to get to, or additional important part, we have 9/11/12. And 9/11/12 911-8 C sets forth several affirmative defenses which the rules say what?
Use them or lose them.
Well, it actually says a party shall set forth affirmatively, and it lists a whole bunch of affirmative defenses. Can anybody name those off the top of their head?
Waiver, certain process, jurisdiction, venue, latches.
Well, all right, let's go through them. Anybody got the rules? 911-8C, accord and satisfaction. We're not going to do a tutorial on all these, what the substance of these are, but arbitration and award, discharge and bankruptcy, duress, estoppel, failure of consideration, fraud, illegality, injury by a fellow servant. Now, in the breach of contract case, did somebody set forth injury by a fellow servant as an affirmative defense?
Yes, well, I've got a case right now which did that. It was a suit on no guarantees. Like injury by fellow servant to the answer.
Okay, and is that a good defense?
I want to know who the fellow servant was.
You would set forth the defenses that you have some factual and legal support for, correct? You don't just list them because 911-8C says you shall set forth these defenses. All right, latches, license, payment. That's one that a lot of people forget. If you have, if they're alleging $100,000 and you've made the last two payments that lowers it down to $90,000, you better raise payment as an affirmative defense. Release. If you had some previous dispute and somehow or another you were lucky enough subsequent to the time the facts arose in the current case to get a broad general release from somebody, even if they never even dreamed that that's what they were releasing, if the release says that you're released, you can raise that as a release. Res judicata. What is that?
Already decided.
Claim preclusion.
It's already been resolved in a previous litigation somehow. Statute of frauds, statute of limitations, and waiver. So every time I answer a complaint, I have doubts, and when I have doubts, what do?
Read the rules.
Read the rules, because inevitably you're going to think you know it, and then you're going to forget when you go, oh my gosh, client did mention this. I actually may have some facts to support this affirmative defense. So under Rule 911-8C, you raise it. Now, there were some other defenses which can either be done by motion or raised in your answer, and some of those were mentioned earlier. Those are the 911-12B defenses, and those are lack of jurisdiction over the subject matter, lack of jurisdiction over the person, improper venue, insufficiency of process. What is that?
Class
Well,
one.
way they serve it was right.
No, insufficiency of process.
Summonses signed or issued by the clerk.
Yeah, lack of a summons, for instance, or as you were saying, Sam, the summons isn't signed or issued properly. Insufficiency of service of process. Now, what would that be? We talked about that last time.
A proper person didn't serve it, wasn't served on the registered agent.
It was given to your 3-year-old daughter while driving her tricycle out in the driveway.
Okay.
Something like that. Failure to state a claim upon which relief can be granted. Should you always raise that one? Seems like it's in every answer I ever see. Do you always raise failure? Let's say it's a 1-count complaint and it's so-and-so executed a note, I gave them the money, they didn't pay, I made demand. Should you owe it, and therefore I'm entitled to recover the money on the note? Should you raise failure to state a claim upon which relief should be granted?
People do, but I don't think that's right.
I don't think it's right either.
I think if their 1-count complaint was trespass to error, that sounds like that would be the proper time to assert that defense.
And then, of course, there are definitely times when somebody has not alleged the
Right.
elements of a cause of action. But that doesn't mean you should stick it in every single answer. Failure to join a party under Code Section 91119, which is indispensable parties, I believe. So the question there is, do you make them by motion if there's grounds for them, or do you put them in the answer? And if you do file a motion, when do you file the motion? Anybody got an idea when you have to file a motion if you put it in the motion, if you're going to move?
At the time you file your answer, don't you?
Excuse me?
At the time you file your answer.
Well, the rule says 91112B, just after where they have 7, it's a very long thing. A motion making any of these defenses shall be made before or at the time of pleading if a further pleading is permitted. That's what the rule says. Is that hard and fast followed by the courts in Georgia?
12B motion?
If you don't make it at or about the time of your pleading, are you forever barred from raising these?
You can raise it in 12C, or you can raise it in summary judgment too.
So,
But you can't make it as a 12B motion.
and you can also raise,
As long as you put it in your answer. I mean, if you didn't assert it as a defense and you didn't file a motion, the court should not allow you to then raise it on the 12C or summary judgment. But the question I have, since in Georgia you can amend your pleadings at any time before a pretrial order is entered, I mean, it's not like in federal court. I mean, if you don't put it in your answer, you can always go back and put it in your answer.
well, that's subject to a debate. You know, you can come back and say that since they shall have, like with respect to these affirmative defenses in 911-8, since it says you shall make them, you can go back, a plaintiff can certainly go back and argue they can't raise that affirmative, one of those affirmative
I've never
defenses.
actually researched that.
And then also, if somebody does file a motion, let's say they file a motion to dismiss 10 days after they file the answer, then the question is, can they make that motion at the time if they didn't put it in the answer, if it's on one of these 7 grounds? And I've basically seen courts gloss over this language about when it has to be done, but if you want to be safe, I would stick by the rules. Now, what if there's all sorts of junk like that line in the complaint I talked about, and your mother is a whore? When would you have to address that to get it out of the complaint and out of the lawsuit if you wanted to do it? Well, when in doubt, read the rules. All right, 91112F talks about motions to strike. Upon motion made by a party within 30 days after service of the pleading upon him, or upon the court's own initiative at any time, the court may order stricken from any pleading any insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. And so, if you were the defendant and you wanted to get that out of the lawsuit, to be technically correct, you'd want to make a motion to strike to get that out within 30 days of being served with the pleading. And then similarly, there are other circumstances where you can move to strike, and of course the plaintiff can move to strike your answer if you've raised a bunch of junk in your answer that they want to get rid of so they don't have to worry about it in discovery. Now, if you do make a motion to dismiss on one of these 12B grounds, do you have to include them all at one time, or can you do them like one at a time? Like, I'm going to move for lack of subject matter jurisdiction, but if I don't win that, I'm going to come back and I'm going to move for lack of service of process, insufficient service of process. If I don't win that, I'll try improper venue. Can you do that?
Read the rules.
When in doubt, read the rules. All right, 91112G talks about consolidation of defenses in a motion. And it says if a party makes a motion under this code section, meaning 91112, but omits therefrom any defense or objection then available to him, which this code section permits to be raised by motion, he shall not thereafter make a motion based on the defense or objection so omitted, except a motion as provided in paragraph 2 of subsection H of this code section on any ground stated therein. So I've actually had that in a very important case where I was suing companies all over the world, and the defendant made a motion to dismiss for failure to state a claim on one of multiple counts in the complaint, but they didn't raise lack of jurisdiction over the person. And since we were suing companies in far-flung countries, but who had a service an agent in Georgia, we took the position that they had waived all their personal jurisdiction defenses, which was great because we both won the motion to dismiss. We were the plaintiff. We defeated the motion to dismiss for failure to state a claim, and we precluded them from trying to get all those companies that were scattered around the world out of the lawsuit. So it worked really well.
They didn't plead it as a defense? Lack of personal jurisdiction?
They pled it as a defense, but they didn't consolidate it in their motion to
Why didn't they
dismiss.
just move under 12C then?
12.
As long as they preserved it in their answer, I don't know why they couldn't file a 12C motion at any time.
Well, 12C would be based specifically, I mean, that's a motion for judgment on the
On the
pleadings.
It's the same thing as a motion to dismiss, except you don't have to file it with your answer.
Well, because we argued under Rule 12G that they had waived it.
They waived
And
a
they're-
12B motion. They didn't waive a 12C motion. They didn't waive a summary judgment motion.
This should have you representing.
Well,
As long as they preserved it in their answer, it doesn't disappear because they didn't include it in their 12B motion.
That's H1 sub B. Right. Basically, it says defense of lack of jurisdiction over the person, improper venue, insufficient process, or insufficient
You see, they
service
put you on
process.
notice that they contest personal jurisdiction. You can't tell them when they have to raise it.
but if they do file a motion under Rule 12, the rule says they shall not thereafter make a motion based on the defense or objection so
It
omitted.
doesn't say in the section now was just reading.
H, which basically says it's waived if it's omitted from the circumstances described in G like you read, or if it's neither made by motion under this code section nor included in a responsive pleading as originally filed.
Well,
But that's
not to go
H1.
any further, I'm a little surprised by your good fortune.
Well, you know, we make our own good fortune.
Exactly.
That's what we're talking about here. If you got something in the rules
Use
that
it.
you can argue it, and hopefully you'll have some case law along the way that'll help you as well. So when you're thinking about this, you got to worry about what you got to have in there. You got to worry about what you might waive if you don't put it in there. And if you take other actions, such as filing a motion to dismiss, you better worry about what you can't thereafter make or what you're somehow barred from pursuing. Now you can, and if you look at 12H2, that actually says a defense of failure to state a claim upon which relief can be granted, a defense of failure to join a party indispensable under Code Section 91119, and an objection of failure to state a legal defense to a claim may be made in any pleading permitted or ordered under subsection A of Code Section 9117, which we talked about was the definition of pleadings, or by motion for judgment on the pleadings or at the trial on the merits. But those are the ones that are preserved. And I think obvious, and it goes on to say, whenever it appears by suggestion of the parties that the court lacks jurisdiction over the subject matter, in other words, the court has no authority to even act, the court shall dismiss the action. So that's preserved as well. But the real thing is, if you want to make your client happy, you want to get these things right so you're not fighting like cats and dogs over whether you have the right to make a motion or not. Because what they want to do is they want to have you resolve their case, win it, and as narrow with as few things to fight over as possible. And so if you just don't step outside the rules, unless you got a really good strategy reason to do it some other way, it's a lot better not to have these side fights about whether, and also you don't want to lose the sleep over whether you did it right or not. It's a lot better to just do it right in the first place. Okay, so we've talked about the general rules of responding to the factual allegations. We've talked about mandatory affirmative defenses. We've talked about motions that can be made to get rid of the case based on various 12B motions. And we've talked about the potential waiver of those defenses or an inability to bring an additional motion, even if it's not a waiver. What happens if a motion to dismiss is filed in a state under Rule 12 in the state of Georgia, state and superior courts?
You still have to answer.
You don't have to answer. What if you win? If it gets dismissed, you don't have to have an answer.
You're in default if you don't file an answer.
Now, that's a good question, though. Is if you don't file, are you putting all your eggs in winning the motion to dismiss? I don't know. I don't know if that relieves you of the default, but it's certainly a huge gamble.
You definitely want to answer because unless the answer is going to be you admit everything and there's some criminal violation or whatever, you definitely want to answer, because if you lose that motion to dismiss, then you're in default and you can't get out of it. Now, what if you get the case in and it's 35 days after it was served?
Move to open default, pay the costs.
Do you have to move to open default?
Oh, I'm sorry, you just
Once that's
you open
right,
default,
45
file an
days.
answer.
Okay, what do? You file an answer and then sometime later pay the costs?
No, you gotta do the same
All at
time.
once.
Okay, so there is
They won't take it.
What cost is paying?
You're paying the cost they paid to file the petition. So, yeah.
Yeah.
The filing fee.
I've seen some instances where they've actually taken the answer even if you don't pay, but you're still technically in default, where they've allowed someone to file and
Yeah.
got the fee and they're done.
Well, I know in Fulton,
Yeah.
you're gonna get them in money before they take your answer.
Well, so the practice pointer is you can automatically open a default within how many days after service of the complaint? And so within 45 days. But I would get a receipt showing zero balance on the court costs at the court on the same day, maybe even if it's got a timestamp on it before you file the answer. So you can show for sure that you paid the cost before you file your answer, and then you're out of default. You don't have to move to open default. We will not go into moving to open defaults that are already solidly in place. But I actually ran across this the other day. So what if you get a stipulation on the 35th day from the opposing side that you can have an extension of time to respond to the complaint in another 20 days?
I've seen it done. I don't think it's proper, though. I don't think they can extend the date once it's passed.
I agree. I actually got that stipulation and I went, whoa, wait a minute, I'm going to go ahead and spend the $212, file an answer. And what I did was I made a deal with the other side. I said, look, my client wants to settle this. We will file just a rote answer denying everything, and then the stipulation will say we can file an amended answer to clarify things within 20 days, rather than spending. It was a 200 paragraph complaint, so far that's worked. I don't see there's going to be any problem with that, but it avoids you getting in trouble with the answer that you file if you're just going to go through and deny things. and I actually put that in the answer. We will file a clarifying answer.
What is Rule 6 says something about extensions as long as the time has already expired.
Yes, I believe I would prefer, well, it is Rule 6 regarding time, unaffected expiration of term. I won't try to read it, but I will say this. I concluded that if the time has expired for you to do something under the rules, that, and particularly in connection with default, you can't just agree to extend it.
I agree.
And so, it's a couple $100. Definitely take the conservative course. You don't want it, the slick attorney on the plaintiff's side coming back later and saying, Your Honor, we never even needed to prove this case. The other side's in total and complete default, even though they answered they never got out of default. Okay, so what else might you have to do with your answer if you got a complaint against your client?
I'd have to verify it.
Yeah, you might have to. Why would you have to verify an answer? And what is a verification to start with?
It's a verified complaint. You have to file a verified answer.
Repeat that, Mark Carter.
If it's a verified complaint, you have to file a verified answer.
Okay, Don, what is a verified complaint?
Or if you're seeking in a counterclaim, relief that would require a verified pleading.
Right.
Well, it's a complaint that has a signature by the party itself saying that the contents are true.
Okay, so a verification is made by somebody that has personal knowledge of the facts set forth in the pleading, stating that the facts stated in there are true and correct. Is by doing so as a party swearing that the legal defenses are going to hold tight and win? No, they're not responsible for the legal conclusions. Natalie?
What's the penalty, though, for if you have a verified complaint and somebody doesn't respond with a verified answer? Is there any penalty against that party for not responding with a verified answer? Because I've seen that happen.
All right, well, what rule did we look at earlier concerning getting rid of pleadings with insufficient defenses?
Strike it.
We could move to strike the answer. The plaintiff could come back and say they filed an answer. Let's move to strike it. It's not appropriate. What is it, 910 something that requires the verified answer? And so if you accidentally or couldn't get a verification from your client in response to a verified complaint, should you go ahead and file the answer anyway to make if you're down to your deadline?
Yeah, I think you should. I think there's lots of case law that says that that's a medical defect.
That's right. You can come back and file a verified answer before the motion to strike is granted, which conservatively you'd want to do. If you got a motion to strike an unverified answer, you would want to answer it fast, even though the court should allow 30 days for you to respond to the motion to strike. You would be in a bad way if the court went ahead and granted the motion to strike before you filed a verified answer by amendment. Did you have a question, Debbie? Okay. Okay. So what else might you have to have in connection with an answer to a complaint?
Compulsory counterclaim?
You could have a compulsory counterclaim. What could possibly make a counterclaim compulsory?
Read the rule.
Yep, read the rule.
All right. What does the rule say?
A pleading shall, and this is 91113A,
91113A.
a pleading shall state as a counterclaim any claim which at the time of serving the pleading the pleader has against any opposing party if it arises out of the transaction or occurrence that is the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction.
Okay, so if you don't file a counterclaim that's arising straight out of the same transaction and occurrences that have been alleged against you, your client, and there's nobody else that's involved in this situation, what happens to your claim? It's a compulsory counterclaim for a reason. Give you a hint.
Be barred.
You can be barred from bringing it in the future. So obviously, one of the things that ought to go through your head as your attorney is to ask your clients, not only do we need to look at the responses to these allegations, do you have anything against the person who sued you that arises out of the same transactions that he's suing you on, and is there anybody else that's involved that would have to come into the case? Now, let's assume that you've got an indemnity agreement from another party, somebody who's not the plaintiff, that indemnifies you for the acts that you're being sued for by the plaintiff. Anything you need to think about there?
Third-party claim?
Third-party complaint. If you were to file a third-party complaint, in other words, make a claim against this other person to try to get them to pay whatever it is that the plaintiff is trying to get you to pay, when do you have to do that without an order from the court?
Every time that you answer.
When in doubt,
Read the rules.
read the rules. 911-14. In order to, you have a right to do that within 10 days of the time you file the answer. 10 days after he serves the original answer. So if you serve it on one day and file it the next, which day starts your time? The earlier one. Okay. So just remember, if you don't go ahead and do your third-party complaint, you might have to go through an extended process of making a motion with the court, etc., to get approval to bring that third party in. How would you do that? This is sort of out of the day's lesson, but 911-21, you'd have to move to add a party, etc. So you want to, if you're going to keep it simple, keep your costs down, you know you got the third party complaint, you want to think about it at the time you're preparing your answer so that you can go ahead and make provisions for filing third party complaint on a timely basis, so you don't have to go through a lot of machinations to get that person in the lawsuit. Okay. With respect to the counterclaim, let's assume that somehow or another this counterclaim is of a nature that the plaintiff might have an additional party who could help pay the sums that you might win on a counterclaim. What should you take into account?
Well, you should make sure that you're not doing something that's gonna, if you're thinking, sounds like what you're talking about is insurance. If you're thinking about there's insurance available, be careful in how you're crafting your allegations so as not to destroy insurance. So thinking about, what exclusions might apply, how it might be, how an insurance company can maybe use it against that plaintiff to say there's no coverage.
Okay, so you got to think about what kind of claim you have against the plaintiff. Think about what kind of insurance the plaintiff might own that could potentially pay that claim if you indeed want them to be able to pay the claim. And think about whether you want to just let yourself spout forth in a rant and rave in the counterclaim, or whether you want to perhaps even hold back some contentions or allegations that you might otherwise make so that you can preserve coverage on the plaintiff's part with respect to the claim you're making against them. Give you an example. If you think the plaintiff was intentionally doing something to you that gives rise to this counterclaim, but you think they might have some sort of liability coverage, and you want to actually get the liability insurer to possibly pay it, then don't allege that everything was intentional. Allege that it was negligent. Because if you allege that it's intentional acts, the insurance company is going to potentially say, defendant says everything you did, plaintiff, was intentional. We exclude intentional torts, so there's no coverage.
I think this applies to if you're the plaintiff. And we're not talking about complaints in this section, but whether it's a counterclaim or it's just an original petition, that's something to also consider. And you can sort of do it alternatively, like allege intentional acts as well as negligent acts, but you want to make sure you got those negligent acts in there as well.
All right, the general idea is, especially these days when people are short on money, if you can get insurance involved, sometimes it makes all the difference. One, whether you can get the case resolved, and two, if you did win it, whether you're going to be able to collect. So you don't want to ignorantly knock out the possibility of insurance coverage unless you're doing it for a very specific reason. The other thing is, sometimes if you can just trigger insurance coverage on the other side, the insurer will come in and start defending that person, which you could argue is bad, but on the flip side, sometimes the expenses the insurance company starts to expend defending, the insurance company will come forward and say, we don't think we have any ultimate liability on this claim, but we will pay to get rid of it. And so that can be helpful as well. One of the things that we encourage here at Taylor English is, if you're either bringing a complaint or bringing a counterclaim, is to talk to some of our insurance coverage lawyers about what you might want to purposefully omit from a claim, or how you might even craft your answer so as to not destroy coverage on the behalf of your client when you're answering. Or importantly, if you have a multi-count complaint as a defense attorney, if your client has coverage, you want to think twice before you move to dismiss the only claim that will give coverage to your client for the defense of the whole action, to get rid of it, because then your client's going to be standing there naked with no defense coverage, meaning the cost of defending the lawsuit. And so that would be a bad move for you to make. In order to, you might get rid of a claim that they're never going to be able to succeed on anyway if you're the defendant, but at the same time you'd eliminate any chance of your client having the defense costs covered.
So that's why it's so tough to represent the company and the folks who have potential D&O coverage, because from the company's perspective, you want to keep them in the lawsuit as long as possible. On their behalf, they want to get the heck out of Dodge as quickly as they can. And that's why it always astounds me how I see the same counsel representing the company and the individual defendants, when on the face of it, they have different motivations with respect to the D&O insurance.
Right, and you got to be very careful from a conflicts perspective. If you're a defense counsel, especially if you're getting paid by the insurance company, regarding what moves you make, because your duty is to whom if you're a defense counsel being paid by an insurance company?
Client.
And who's the client?
The company.
The insured. The insured who you're representing is the one to whom you owe your duties. So you don't, for instance, want to take moves that an insurance adjuster might tell you have to do because we want to cut off the coverage in this matter, if your client is going to be negatively affected by that. So those are the many of the considerations that we would ask for you to think about when you're answering a complaint. Now, I have distributed everybody should have a defensive pleadings checklist that was compiled by John Richard and Bill Leonard over time. That's come out by emails under the Quillian's Colonel's header. It is fabulous as a go-by to think about all sorts of things that you might use as a defense, all sorts of defenses you might raise, all sorts of things you might be reminded of to include in your answer or counterclaim. And also I've sent several other documents, one of which was from the Georgia Bar Journal a number of years ago, but it goes into various statutory defenses that nobody's really going to think about unless they've run across them in the past, such as you're being sued by a company that's not qualified to do business in Georgia but was supposed to be qualified. that can result in a dismissal, and other types of defenses that you just have to know about them in order to raise them. So with that, I appreciate your participation today. Come back next month.
Thanks.
Thank you.